I want to play this audio from you. This came from some reporters on the Hill in a conversation with Senator Thom Tillis. And we're going to start with audio soundbite 13. Listen.
We're not really sure, and a part of what we have to do is get the numbers to figure out what's the most efficient way to do it. So we're trying to capture a lot of baseline information, whether or not it has to be indexed or it has to be some sort of automated conduit to get the juvenile records. But then there's the other problem you have is you can't just upload all juvenile records because you have to go through an adjudication process on a case-by-case basis to have them unsealed. We have to determine whether or not we can require an applicant to authorize the unsealing, whether or not that would expedite it. But it could take some number of days to get to the record.
So does it create a wait period for most people who are 18 and 21?
We're not creating a waiting period, but we are creating. Depending upon how well we can automate it, could influence some number of days before they could actually get cleared. But that's all mechanics that we're working through.
There's about 27 states right now that currently require that there is a search of the juvenile records. Now, would they somehow be uniform, obviously, with the federal law? How exactly would their current laws?
We're working through it. Right now, what we're not drafting text yet. What we're trying to do is settle a couple of other details on what we want the text to address, and then that's when we get to that level of detail.
Now, if you get the newsletter, I sent this out to you last night for our subscribers. So he's saying, it was interesting, he was saying, well, it doesn't create a waiting period, but it kind of does. It does create a waiting period. But he was explaining the process through which you have to go, and this is what I've been reading because it is different state by state, so it's a lot to take in. So you actually have to go through a whole other separate legal process to unseal records of juveniles. I'm talking again, the same violent felony criminal acts committed, like say by a 17-year-old, they turn 18. They have to go through a whole other process to have those records unsealed in order for that to establish a record in adulthood. Now, why do I bring this up? Why is that important? I don't know how long it takes. And that's what he was discussing there, because apparently it's different state by state. There's no uniformity, which makes it difficult. Secondly, he was very insistent, and I think his statement there is that they don't want a waiting period for purchase, and it didn't sound like he was interested and raising the age, which we're going to talk about here coming up as well. But it sounded as though he's like, this is unavoidable because you have to unseal these records. Interesting. I wanted to play this because he was asked by Carrie Pickett with the Washington Times. He was asked, is this going to change anything on the form that you fill out when you go to purchase a firearm? And this is where ATF gets involved. Listen.
Could this legislation also perhaps change the 4473 form in any way?
Say again?
Could this legislation anyhow change the 4473 form in any way, shape, or form as far as the questions that are asked?
We haven't discussed that. It may, at least on the juvenile front, because that's not a question that's asked today. But we haven't gotten to that level of detail. That's what I'm saying. After we get the pillars defined, then we got to get to people that can work through the technical details. May very well.
No, that's what it. So I don't know how they solve that if that's a state's issue. See, I would think that Lindsey Graham, instead of retooling his damn red flag law bill, why not incentivize states for violent felony criminal behavior? Why not incentivize the unsealing of those records so that can be established into adulthood? Now, people will say, oh, that's why I'm very careful about violent felony criminal behavior, because there's dumb kid stuff and then there's violent felony criminal behavior. They're saying, I'm going to kill you online and you're joking, and literally sending rape and death threats repeatedly to women and making yourself an imminent threat. There's a huge difference. So the one objection, and this was, I had mentioned this, I think it was on Instagram, and someone was like, oh, well, what about the rights of, I'm like, well, what about the rights of the innocent 18 to 21-year-olds who've never done a single damn thing? because of the violent repeat felony criminal actions of a 17-year-old that turns 18. Their records are sealed. In California, they had a couple of these juvenile delinquents. Their records were expunged. Why would you? I've yet to see a good argument as to why that should not establish an adult record once they turn 18 for violent criminal felony behavior.